Hi, folks. My name is Killian Garvey. I'm a planning barrister at King's Chambers, and I'm here today to talk to you about the new NPPF. Very sincerely appreciate how many of you have wanted to attend today's webinar, and I hope you will get something out of it. I certainly have, because knowing that I'm presenting this webinar has forced me to swat up on the new NPPF. So thank you for that. My objective with this webinar is to talk through the NPPF, and I'm effectively just going to go through it in order and just flag up what's changed. I'm not going to be doing a commentary on whether these changes are good or bad, because it's not my role. Really, and I'm also not directing this to any particular group, whether that be the private sector or the local planning authorities or otherwise. It's simply meant to be a discussion about what these changes are and just talk through them and try and explain from a practical point of view what the new language is. There are some changes to the background, including the planning practice guidance and the standard method. And there's also, the government said they will be making changes to the planning practice guidance in respect to viability and flood risk. I'm not going to be focusing much on those things that are happening in the background. My role really is just to focus in on what the new NPPF is doing in the new text. So I'll be doing my best as I go to be answering questions. Obviously, I want to make progress, so I won't be able to answer all of them, but I'll do my best. So if you've got questions, please raise them in the chat function. To that end, I can see some people have already added some questions. Yeah, Mike. So everyone except for me is on mute. That's not just my ego. It's just to make it workable. But if you've got questions, please do chime in there. I should say that this session is being recorded. The recording will be available in the new year. So jumping into it, the headlines on the new NPPF, it's intended to encourage growth, in particular in respect to housing. There is some what I regard to be sort of unnecessary tinkering with wording, i.e. changes to wording, and I'm not quite sure whether it's going to actually have any practical difference in the way in which we approach these policies. And then there are some aspects of national policy which have changed, in particular in respect to the Greenbelt, and it wouldn't shock me if some of these changes were not intended. So in the Greenbelt section of this talk in particular, we'll see how those changes have taken effect. I'm going to be sharing my screen in a moment, actually going through them. But I should say, anyone who has a smartphone, you'll be familiar with the fact that when you get a new operating system, maybe a few days or weeks later, you get an update saying there's been a few bugs that have been fixed. I anticipate something similar happening here with the new NPPF, because there are some errors within the new NPPF which I anticipate being ironed out. So if I share my screen and get the new NPPF up on the screen, one such error which was highlighted to me, there are others, but this one was highlighted to me by Neil Tiley at Pegasus Group. Hopefully you're seeing the new NPPF here. And what we'll see in footnote 8, I'm going to be taking this in order, but just jumping around. Footnote 8, which is talking about applications for the provision of housing, it tells us at the end, so these are circumstances where policies can be considered to be out of date. At the end of footnote 8, it says, see also paragraph 227. Well, if we scroll down to paragraph 227, we will see a paragraph solely dedicated to minerals and mineral planning authorities, nothing to do with housing. Clearly, there wasn't meant to be a cross-reference to paragraph 227. So there are errors and typos and bugs within the new NPPF. So this is sort of version 1 of the new update, and I anticipate we'll get a new version in due course. I should say, it would be helpful if someone in the chat function can just flag up to me. When I shared my screen, then I presume you could all see the new NPPF. Great, I can see someone's thumbs up. Okay, brilliant. Okay, well, with no further ado, we're going to jump straight in. As I said, ask your questions as we go. I'll do my best to answer them. So, new NPPF, achieving well-designed places. We've seen there's been a deletion of "and beautiful." Some commentators have made the observation that the word beautiful seems to have been stripped out. It's not entirely stripped out, as we'll see, because, for example, in terms of the social objective of achieving a sustainable development, you've still got beautiful and safe places. And the word beautiful buildings appears later. So it's not entirely stripped out of the new NPPF. I think this falls into the category of tinkering, to be quite frank, removing it. Some people celebrate its removal because the word beautiful is obviously an inherently subjective judgment, but it's still there as part of national policy. There's also, as I said, I've said that there's some tinkering, and on most of the tinkering with language, I'm not going to be focusing on. But if we see here, I've highlighted this, that we're told that NPPF provides a framework within which locally prepared plans can provide for housing. Well, if we compare that to what the previous iteration of the NPPF said, we can see that it used to say, provide for sufficient housing. So the new version has removed the word sufficient. I'm really at a loss as to what the reason why anyone felt the need to remove that, particularly in the context that later on in the NPPF, you can still see that the word sufficient still appears. Paragraph 20. This is the new version of the NPPF here. This is the old version over here. You can still say that strategic policy should set out an overall strategy for the pattern, scale and design, quality of places, and make sufficient provision for homes. So again, this is indicative of what I mean by tinkering. I don't know that this is going to make a whit of difference. I'm not quite sure what was meant to be achieved by removing these words. I doubt anything is the answer to that. Okay, so moving forward, where we get to paragraph 11 of the new NPPF, what we see is new NPPF uses the language of provides a strong reason for refusing development. So for decision taking, you're going through the same process where you accord a development plan, you get permission without delay. You then move on to the context of where the policies are out of date, which hasn't significantly changed. There's later parts about how we deal with housing, land supply and whatnot, which we'll come to. But so far, the structure of this is relatively unchanged. But where we get to this section, which is talking about areas or assets of particular importance, provides a strong reason for refusing development proposed. Now, it used to say the word clear reason for refusing development proposed. I'm not clear, pun intended, whether there is any difference at all in the use of the word strong or clear there. Ultimately, the way in which, for practical purposes, let's assume you've got an issue with a national landscape, for argument's sake. That's one of your sort of footnote 7 restrictions. And you go through the national landscape policies and you conclude that the harm to the national landscape is such that that the development proposal should be refused, i.e. you haven't overcome the harm to the national landscape. Well, whether you describe that as a strong reason for refusing development proposed or a clear reason for refusing development proposed, I'm not sure in practical purposes whether that makes a whit of difference. I also note footnote 7, it used to be here. It's now been moved to after the word importance. Again, it seems like unnecessary tinkering. It doesn't seem to achieve anything to me. And I think this reference to strong, again, as opposed to clear, doesn't strike me as making any meaningful difference. Then we turn to the tilted balance, which introduces this new text here. So we've got the traditional test of i.e. the tilted balance of significant demonstrably outweigh the benefits. But then having particular regard to key policies directing development to sustainable locations, making effective use of land, securing well-designed places and providing affordable homes individually or in combination. Now, having particular regard, it might be said, well, that elevates these issues to being somewhat more important in the context of the tilted balance. And notionally, I get that insofar as, well, it's there, have particular regard. So any decision makers clearly got to apply their mind to those things. But how important those matters are, it strikes me, it's not as if they were unimportant previously with the previous version of the NPPF. And how important they are strikes me as always being site-specific. I mean, there might be occasions where making effective use of land is really important on the specific scheme, or it might be a relatively benign and straightforward issue. And I'm not certain that having particular regard actually does elevate that or undermine that issue, whether if you were to delete this. So again, this doesn't strike me as something that is going to meaningfully make a difference in how we approach the tilted balance. I'd be really interested to know if others take a different view. I'm not quite sure what this achieves, except for the notional point that it elevates these issues, but whether it actually does is always going to be site specific. Okay, so I can see some people have jumped in. Okay, so Jeff's asked, does it give opportunity for lots of revisions on design, for example? Well, that's a perfect point. What I mean, Jeff. So let's assume you've got a scheme and design, securing well-designed places. So clearly, it might be said, well, design is therefore elevated as being more important than it previously was in the context of tilted balance because of this having particular regard to key policies for securing well-designed places. Notionally, yes. But if under the previous version of the NPPF, if you had a bad design, that would seemingly still go into the tilted balance and it would still be afforded whatever weight it was, bearing in mind how poor the design was. And I don't know that this really changes that. I don't think it gives local authorities license to suddenly say, oh, we wouldn't have previously brought design in, but now we will. Because it's either good or bad design and you put that into your balance as you would previously. So I don't think it's actually going to meaningfully make a difference. It's, as I said, it's only notionally it could do. So Peter says, a reason can be clear but not strong. I mean, to my mind, that is semantics, Peter, because when you actually, I mean, again, let's take another example, heritage, for example. So that's a, let's do a worked example and let's actually try and think of whether strong or clear makes a difference, because I can see some people are weighing in on this debate. And I should say, this is interesting to me as well, because the opportunity is for me to learn as well. So let's do a worked example of actually applying footnote 1. And I'm going to use heritage just for argument's sake, because the heritage policies haven't changed in respect to the new NPPF. So we've got a scheme. Let's assume it doesn't accord with the development plan. It's outside a settlement boundary. We'll take a housing scheme. Doesn't accord with the development plan, outside a settlement boundary. So we know it doesn't conform with 11C. We're into 11D. Let's say, for argument's sake, local authority don't have a 5-year housing land supply. So we know that the most important policies for determining the application are out of date. We then jump to the first Roman numeral, the application of policy in the framework to protect areas or assets of particular importance provides a strong reason for refusing development proposed. We've got a heritage issue. We know that there's an issue, and let's assume it's less than substantial harm. There's going to be a little bit of vertigo as I jump down to the relevant section on heritage. I still haven't memorized all the new paragraph numbers, but if we get to the equivalent of the less than substantial paragraph, what was 208 is now 215. So where a development proposal will lead to less than substantial harm to the significance of a designated heritage asset, this harm should be weighed against the public benefits of the proposal, including where appropriate, securing its optimum viable use. So the exercise we're doing here is exactly what we were doing pre this new NPPF, which is we take all the benefits and we weigh it against that less than substantial harm. Now let's assume the decision maker concludes that all those benefits do not override that less than substantial harm. So the public benefits don't outweigh. Okay, let's go back to, so that's the conclusion. Let's go back and think about what does the inspector or decision maker do with that? Now, if the public benefits don't override the less than substantial harm, clearly that would provide a clear reason to refuse development. Why wouldn't it provide a strong reason? I mean, ultimately, to my mind, it's the same point. Your public benefits don't override the heritage objections, the heritage harm. Why isn't that not a strong reason to refuse development? So I mean, if it's a clear reason, to my mind, it's a strong reason. So I just don't see that there is a practical difference there. I mean, you could say, well, West, we didn't override the heritage harm, but that's a medium reason to refuse development. But in reality, if you haven't overcome the heritage harm, you're going to get refused. So I don't know that it makes an actual practical difference. Yeah, so I can see some people are taking it as, some people seemingly agree with that. Some people think that the word strong elevates this to being something more significant. We will see. I'm not convinced in practical terms that the change in language is going to make a difference. whether it's strong or clear. It's ultimately how the real question is, have you overcome? Because what footnote 1 does is it takes you to a different test. That's always what Roman numeral 1 does. It's diverting you to a separate test. For example, flood risk. If you're directed to the test of, have you done your sequential test, for argument's sake? If you haven't done your sequential test, well, whether you describe that as a clear reason or a strong reason, in reality, I think it's going to be the same point. Have you overcome the particular test that's relevant to these various points, whether that be very special circumstances, whether that be sequential test, whether that be your public benefits outweigh your less than substantial harm? Ultimately, I don't know that the word strong or clear makes a difference. But anyway, that's my view. I can see some people take different views, and that's part of the fun of this. Okay, and we'll see how that plays out. Paragraph 14 has remained unchanged. I know lots of people were anticipating a change there, albeit the consultation version didn't suggest a change. But paragraph 14 of the NPPF has remained. Moving forward, let me just, before I move on, see if there's others who are weighing in. Well, Tom, you said the difference between clear and strong might be more pronounced with subjective matters such as design, layout, and landscape. But of course, they are not footnote 7 points. That's, well, landscape can in national landscape, but that again doesn't really change the test. That's sort of why I'm saying I don't think the difference is one in actual reality is going to lead to a different outcome. Put it another way. If there was a scheme that was refused last year because an inspector said there's a clear reason to refuse a development proposed, I wouldn't be suggesting to any of those developers run the case again and just argue, well, it might have been a clear reason, but it's not a strong reason. Moving forward, in terms of local plans, there's a bit more emphasis on cross-boundary interaction and cooperation. You can see that local planning authorities will play a vital and increasingly unsustainable growth is delivered by addressing key spatial issues, including meeting housing needs, living strategic infrastructure, and building economic and climate resilience. And there's here an emphasis on requiring collaboration, strategic policy-making authorities to make sure that their plan policy align as fully as possible with those of other bodies where strategic relationship exists on these matters. Which I thought was a bit of an interesting language, which is, if you've got a strategic relationship, make sure you collaborate, which would rather suggest, well, if you don't have a strategic relationship, then you don't have to collaborate. I.e., if you don't get along, you don't have to collaborate. That's, in the puerile sense, how I read it from at first blush. I'm not sure it's going to make much of a difference. What I can say is that there seems to be an emphasis on greater interrelationship between local authorities. And there's an acknowledgement here that where plans come forward at different times, there may be a degree of uncertainty about the future direction of relevant development plans or the plans of infrastructure providers. In such circumstances, strategic policy-making authorities and inspectors will need to come to an informed decision on the basis of available information rather than waiting for a full set of evidence from other authorities, i.e., you can make educated guesses. You don't have to wait for some sort of certainty. Moving on, I should say a lot of what I'm going to go through is probably going to be relatively benign. When we get to the green belt, that's when I suspect I'm going to make the next few points that are going to throw some grenades out there that people are going to get excited about. Okay. Where I've not highlighted points, it's because it's either replicates what was there before, or it seems like it's benign, trivial changes that don't meaningfully make a difference. So, for example, I haven't highlighted every time they've deleted the word beautiful or moved a comma around. Delivering a sufficient supply of homes. So we do see some meaningful changes in this part of the NPPF. So we can see that to determine the minimum number of homes needed, strategic policies should be informed by a local housing needs assessment conducted using the standard method in national planning practice guidance. In addition to the local housing need figure, any needs that cannot be met with neighbouring authorities should also be taken into account in establishing the amount of housing to be planned for. To understand the significance of that, we have to sort of compare that to the previous version of the NPPF. And don't worry, Tom, I'll zoom in for you here. Hopefully that's big enough for people to see. So the previous version of this paragraph, you can see, talked about the outcome of the standard method is an advisory starting point for establishing a housing requirement area for the area. There may be exceptional circumstances, including relating to the particular demographic characteristics of the area, The point is, the previous version of the NPPF talked about the standard method being an advisory starting point. The current version rather mandates it would appear, as being the way in which you do it, but with a potential uplift to account for neighbouring areas. So there seems to be less of an opportunity at the local plan stage for local authorities to try and duck out of the standard method. Now, it might be that the PPG comes in and outlines circumstances where you can still potentially avoid the standard method, but the NPPF doesn't seemingly endorse that level of flexibility. Let's just see if anyone wanted to weigh in on this. Jade, you've asked some points about the transitional arrangements. If you're going through a local plan examination now, at what point do these points come in? We're going to come to the transitional arrangements later. I'm not going to spend a huge amount of time on them, I should say, because they're so specific to each local plan. They're not going to be relevant to a lot of people. And they're relatively straightforward to work through. They just have to sort of work through them. But that question I'll come to later. Paragraph 28, not aligned with the test of soundness for plan making. The test of soundness never relied on best educated guesses. Well, this is best educated guesses about your neighbouring authorities, Hannah, not about your authority. But it's that if you're trying to think of a solution in one authority, but you've got to have an eye on a strategic solution across a number of authorities, I think the paragraph I was taking you to was suggesting, well, if you don't know exactly what that other authority are going to do, you don't have to wait for them to tell you and give you that certainty. You can make a guess on the information you do have, i.e. don't let one plan that's not coming forward hold up other plans that can be brought forward. That's my reading on this. Okay, back to new NPPF. There's references to social rent in terms of the type of affordable housing that need to be met, because you can see this is talking about the types of units that need to be assessed and reflect in policies. And in terms of affordable housing, you've got to meet the need specifically for social rent. There's quite a few paragraphs about social rent, which I'm not going to go into any great depth on because they're quite self-explanatory. It's just to flag up. It's clearly part of this government's agenda to have that greater emphasis on social rent. Because where there's a need for affordable housing identified, planning policies should specify the type of affordable housing required, including the minimum proportion of social rent homes required. So it's not just you need X amount of affordable homes, but you need X amount of affordable homes plus you need X amount of social rent homes. Again, just consistent with that notion that social rent is an important type of affordable housing to this government. We then turn to this next section, which is talking again about major development, including provision of housing. And there should be planning policies to ensure that the mix of affordable housing required meets identified local needs across social rent. Again, there's emphasis on social rent. And then we see a section here about the Greenbelt, which I feel like we're just teasing you. When we get to the Greenbelt section, that's when the gloves are going to get off, I'm sure. And people are going to be screaming at their computers at me. But this is just the first glimmer of the Greenbelt issue coming in. And we see reference to the golden rules for Greenbelt development. So we're going to have to, when we come to the Greenbelt section, we might flick back to this later. But it talks about specific affordable housing requirements should be set for major development, including the provision of housing. And that this requirement should be set at a higher level than otherwise should apply and require at least 50% of the housing to be affordable unless make the development sites unviable. This section will make more sense when we get to the later section in respect to these golden rules. And the affordable housing requirement plan within or released from the Greenbelt may be set at a single rate or be set at differential rates subject to the criteria above. Claire's pointed out that the PPG does identify exceptional circumstances for not using the standard method, which is consistent with the point I was hopefully pointing to earlier, but it's that the NPPF doesn't sort of deal with that. And Lawrence said all developers will claim sites are unviable. Well, I'm not picking sides here between private and public sector. Undoubtedly, some developers will claim viability issues in respect to sites. The PPG will be updated, we're told, about viability and the Greenbelt. How that works out, we'll have to see. So moving forward, there's a section here again, which I'm not going to spend much time on, but you can see that there's a new section about mixed tenures in terms of providing a range of benefits, and again, emphasis on social rent. Okay, there's a reference in paragraph 73, which again I think is tinkering, but it's not. This is a point that sometimes is forgotten. These small, it used to say small and medium sites can make an important contribution to meeting the housing requirement in an area and are often built out relatively quickly. This new text has been added, which makes the point that they're essential for small and medium enterprise house builder to deliver new homes. And the simple point is that these sort of 50 unit, 100 unit, 80 unit sites, they're often the ones that can come out of the ground quickly. Because, if you've got a 5-year supply deficit as a local authority, the schemes that you have, which are going to deliver, 1,000 units, they're years away normally. If you've just granted permission, in reality, they're normally years away from houses being built out of the ground, because normally you've got so much infrastructure involved, so many providers involved. Whereas these smaller units, these sort of 50, 80, 100, that sort of territory, maybe even up to 150, you've got small, medium enterprises, one unit, one outlet, sometimes one phase of development, build it all out in one go. They're often the ones that can come out. So that it strikes me that that's just an acknowledgement of those sorts of sites. Okay, moving forward, maintaining the supply and delivery. What we've got, I've made a reference to paragraph 76 because it's more what's been removed than what's remaining in this section. So previous NPPF used to have the provision, which was that where a local authority had adopted their plan and it was less than 5 years old and it had a 5-year supply, they were sort of given a 5-year shield from having to demonstrate a 5-year housing land supply. That's been removed. So now, local planning authorities, from the moment of adoption, they could be challenged on 5-year housing land supply. Again, I'm not weighing in on whether this is good or bad. This is just, that's the meaning of the change. It tells us that the buffers have been reinstated. These were removed in the previous iteration of the NPPF and they've been reintroduced, which would suggest that the housing requirement would go marginally up depending on the levels of delivery that have been seen in the past. Going forward again, just before I move on, any questions on this? Okay, nothing that I need to weigh in on. We see in terms of building a strong competitive economy, nothing particularly dramatic or exciting here. We can see that there's a reference to the National Industrial Strategy, which is new, which is referencing this document here. There's a particular emphasis on planning policy should take particular regard to facilitating development to meet the needs of a modern economy, including by identifying suitable locations for uses such as laboratories, gigafactories, data centers, digital infrastructure, freight and logistics. I know all of you are excited about this change. All of you are working in laboratories, I'm going to assume. There's a change in policy. Clearly, there's an emphasis on this type of development. And then rolling forward, nothing in respect to retail, healthy and safe communities. There's nothing, again, of particular change. I can note that there's this local planning authorities refuse applications for hot food takeaways and fast food outlets within walking distance of schools and other places where children and young people congregate. Any of the parents out there might be excited by this change. It does directly affect an appeal I'm involved in. So that's why I'm more excited about it than most of you will be. There's some tinkering of language. There's some emphasis on sort of post-16 development, and there's an introduction of what post-16 means in the glossary of the NPPF. And we see that significant weight should be placed on the importance of new, expanded, or upgraded public surface infrastructure when considering proposals for development. So some of this change, I'm not in any way trivializing it, but it doesn't require, there's not a huge amount of ambiguity. I don't imagine it's going to make a wave of change in how development is coming forward in the next few years. These sort of changes in language, obviously, it's going to get less McDonald's and whatnot near schools. Let's just see if anyone wants to say anything about that. Oh, how are we defining walking distance in this paragraph? Good point. Well, there isn't a defined definition for the purposes, Sarah's question, for the purpose of that paragraph. I mean, there are other guidance documents which talk about what a walkable distance is. There's Manual for Streets, which talks about 800 meters being minimum, but that, maximum walkable distance is 2 kilometers. Saying that you can't have a hot food takeaway within 2 kilometers of every school would strike me as potentially being quite onerous. So I don't imagine, I imagine it's just pure planning judgment, because not only are we talking about distances, you've got to think about topography, lighting, how attractive is the route, how likely people are going to do it. So all of that goes into the mix. So I don't know that you can prescribe a policy. It's in reality, a kid's going to be going there for, immediately after school. That's what we're really trying to avoid. As Tom said, will it tie into bus stops and other facilities? I mean, notionally, yes, but people are much more excited about the walking distances to the hot food takeaways than I anticipated. So yes, I mean, there isn't a prescribed distance. Tom, you said there's sort of barometers for bus stops and other facilities. That's what I was trying to allude to in terms of what Manual for Streets is talking about, in terms of your 800 meters and your 2 kilometers. But again, I don't know that policy could ever dictate what is an appropriate distance, because it would seem somewhat arbitrary. There will be some distances, there'll be some hot food takeaways which are 800 meters away from a school, but there's no path that gets you there, and in which case you can have reasonable confidence no one's going to do it. You might have other places that are 500 meters away, but you clearly it's a problem because all the kids just immediately gravitate towards there. So I think that these sorts of things are always site specific and comes down to the decision maker. I know that always introduces a level of subjectivity and uncertainty, but such is planning. I'm glad I flagged that up now. I suspect most people missed the significance of the hot food takeaways. That's your one takeaway from this talk, pun intended. Existing open space, there's been a slight change to language. It's introducing this language of and formal play spaces. I think that's probably been brought in. I think it was 97 from memory. No. The previous paragraph that talked about open space. Oh, sorry, 103. It used to be 97 in the version before that. It used to talk about including playing fields. So this has notionally been expanded to now include and formal play spaces. I think formal play spaces probably would have always fell within that definition. I think this probably just clarifies that rather than opens the gate to considering more levels of open space. But the tests remain the same. We then come to promoting sustainable transport, and there's a lot of changes to the promoting sustainable transport in terms of the actual language that's used. I'm not convinced it's going to make that much of a difference. If there are any transport consultants involved, please jump up. I'm going to try and put them side by side. I know that might offend some of you looking in a boardroom. You might have to squint, but the text in green over here, just from a cursory glance, you can see there's quite a lot of language that's been introduced and language that's been deleted in terms of promoting sustainable transport. As we go through, and not even delving into the actual language itself, you can just see there's quite a lot of tweaking that's been going on. But I'm not convinced it's going to make any difference. I mean, for example, if we come to the test in 116, which is normally one of the most important aspects of your highway safety issues, development should only prevent and refuse on the highway grounds if there would be an unacceptable impact on highway safety or the residual cumulative impacts on the road network following mitigation would be severe, taking into account all reasonable future scenarios. So the new language of following mitigation and accountable reasonable future scenarios, that's what's new. Does it change things? Not to my mind, because you say following mitigation, and that might clarify the situation, but it was always understood that you were always having regard for mitigation, i.e. that's what the residual issue was. what's the residual impact after your mitigation? Because I've always seen it that when you're talking about what's the highway impact of a scheme, you think about, well, after we put these highway improvements in, i.e. your mitigation, what's the impact? So I don't know that changes things. And then taking account of all reasonable future scenarios. If you'll forgive the vertigo, I'm going to jump down to the glossary because there is a section, which defines what reasonable future scenarios are, which is a range of realistic transport scenarios, test in agreement with the local planning authority and other relevant bodies to assess potential impacts and determine the optimum transport infrastructure required to mitigate any adverse impacts. Again, I don't know that this was ever being ignored by highway authorities in terms of what do we anticipate coming on the horizon. So I don't know that this meaningfully changes the way in which highway authorities and highway consultants are going to be dealing with schemes one way or another. But I'd be very interested to know if others take a different view. I'm not convinced that any of these changes actually make a difference. So some people are asking about this. So Lawrence, you've asked about, do we think severe impact will continue to limit transport consideration, massive congestion, road safety, therefore continue to overlook connectivity, accessibility and inclusion? No, I mean, to my mind, in when we talk about sustainable transport, there are 4 issues that always come up. And no matter what you do realistically with the language of the NPPF, these are always the things that are relevant and come up. And they are, is the scheme technically safe? And by that, I mean, have you got your visibility displays? Can you get cars in? Can you get cars out? Access, egress internally? Can, your refuse vehicles get in and out? All of those sort of technical requirements to make sure it's safe on site. Secondly, has it got a severe residual cumulative effect, i.e. the actual generation of more traffic? Is that going to lead to an unsafe, severe impact on the wider strategic network? 3, is it in a sustainable location, which is access to services, facilities, bus stops, all those sorts of points, which are always in the mix. And 4, your relevant standards in terms of parking. Those 4 issues, strikes me, they always come up on pretty much any scheme. And I don't know that you can change the language of the NPPF to ignore them because they're always going to be relevant, just as a matter of common sense. So that's why I'm not convinced changing this language really ignores any of those considerations. And Lawrence, your point about accessibility, well, it's still got the language of requiring a genuine choice of modes of transport. That's still in there, and to my mind, decision makers have been having regard for that for decades. That's my own take on it. So Mike Glaze, he said it's not going to change our assessment. Well, I'm glad to hear that, Mike, because it's not going to make it doesn't, to my mind, change anything that I'd be asking you or any other highway consultant on either side of the fence to be thinking about, which is, generally speaking, the 4 points I've just set out there. Someone's going to jump up now and say, you've missed a point, but I'm going to move on quickly to deprive of the opportunity to do so. We've got high quality communications, nothing of interest there. Making effective use of land. There's a new text in respect to brownfield land. So planning decisions and policies should give substantial weight to the value of using suitable brownfield land, and then proposals for which should be approved unless substantial harm would be caused, which is a little bit more of an impetus to actually be granting these schemes for brownfield development, previously developed land. We've got our mansard roofs, which come in, seismic changes in planning policy there. And then we get to well-designed places. And I'm flagging up the word beautiful still retained. So to the extent of which beautiful has been deleted in some aspects of the NPPF, it's still there. So I'm not sure why deleting it in some places and not others. Because this section used to be called Achieving Well-Designed and Beautiful Places, I believe. Achieving well-designed and beautiful places. They've deleted the "and beautiful," but it's still there in the text, so I'm not sure it makes a difference. Again, we've got a new bit of text here that where this text is new, that where applicable, that applicants should provide sufficient information to demonstrate how the proposals will meet the design expectations set out in local and national policy. Well, more fool any applicant who wasn't doing that beforehand, because that was I don't think that makes a difference. Presumably, you'd always have to set out how you meet the design requirements where design is a relevant consideration. And then we get to the green belt. Right, this is the point where I should be wearing boxing gloves, I suspect, as people get upset with me. Let me just jump to some questions before I move on to the green belt section. Ollie, it may increase the burden of assessment at the application stage to consider reasonable scenarios. Ollie, I notionally see that point, but in reality, it's reasonable future scenarios. So if it was reasonable beforehand, why wasn't it reasonable now? So, if a local authority, a higher authority, asked you to look at it before that changed the text, it was always reasonable. So it was reasonable for them to ask you to do it, irrespective of the change in the language of the policy. Then we can see Darren saying beauty in the eye of the beholder. Absolutely. That's why so many lawyers hate the use of the language. It's not for me to comment. Let's jump into the green belt. This is where we get exciting. Okay. Greenbelt says 5 purposes. These are unchanged, but they take on a different significance when we come to the grey belt. Because I want you to think about purposes A, B, and D, because when we come to grey belt, we'll see the significance of them. A is unrestricted sprawl, B is use of a coalescence point, and D is historic towns, which were the original 3 purposes of the green belt when the green belt was first proposed in national policy many, many years ago, many decades ago. So we'll just put a pin in that, and we'll come back to this when we talk about grey belt. We then get to exceptional circumstances test, which tells us that exceptional circumstances can include, but it's not limited to, instances where an authority cannot meet its identified need for homes, commercial, or other development through other means. So exceptional circumstances is not being able to meet your needs, which is quite a shift in policy. And it's not just need for homes, it's all types of needs that can amount to exceptional circumstances. So I suspect the development industry will welcome that change in language. And it tells us that authorities should review greenbelt boundaries in accordance with the policy in this framework and propose alterations to meet these needs in full, unless the review provides clear evidence that doing so would fundamentally undermine the purposes of the remaining greenbelt when considered across the area of the plan. I.e., there's an impetus here that when you're at the plan-making stage, you should be trying to meet your full needs unless you're really going to be fundamentally undermining the remaining greenbelt, which is quite a strong shift in policy for your plan-making stage. Then there's sort of a sequential approach that's being suggested here to how one approaches this, which is where it's necessary to release greenbelt land for development, plans to give priority to pre-developed land, then grey belt, which is not pre-developed, and then other green belt locations. So this is how grey belt is relevant in the plan-making context. We'll come on to in a moment what grey belt is, but in a plan-making context, PDL first, then grey belt, then you look elsewhere. And it's sort of that sort of sequential approach when you are releasing land. You can see some people are jumping in. So David says, a lot of emphasis on making it easy to develop in the greenbelt. How these changes relate to non-greenbelt countryside when applying new paragraph sequential test on finding sites. It's easier to develop in the greenbelt than non-greenbelt countryside. I wouldn't agree with that, David, because I'd suggest this notion makes it easy to develop in the greenbelt, but it's still the greenbelt. There's still high tests to overcome, which wouldn't be applicable in a countryside location. And remember, one thing that's often forgotten about, and I'll come on to this in a moment, but just because you've overcome the greenbelt designation, that doesn't mean all other things with your site have fallen away. It's still in the countryside. So, I suspect it's in the countryside. So you might have both your restrictions in relative to the countryside on that site and the greenbelt restrictions. So just because you've overcome the greenbelt restrictions, it doesn't mean that the policies that restrict development in the countryside fall away. They remain as they do in the site that's not in the greenbelt. Moving on, where greenbelt land is released for development through plan preparation or review, the golden rules in paragraph 156 below should apply. So we'll come on to what these golden rules are in a moment. We then get to 153. Now, I said in my opening that there are some changes in respect to greenbelt policy, which I anticipate are unintended. this is the first one. And I'd love people to jump up and down and say that I've got the wrong end of the stick on this one. So 153, which tells us that when considering any planning application, local planning authorities should ensure that substantial weight is given to any harm to the greenbelt, including harm to its openness. Fine. That doesn't suggest a change, except for when we see footnote 55, which tells us other than the case of development on previously developed land or grey belt land where development is not inappropriate. There's two ways to read this as I see it. That's either saying previously developed land or grey belt land, they are appropriate, which can't be correct to my mind, because if we take previously developed land as an example, previously developed land isn't automatically appropriate development. It's only previously developed land which would not cause substantial harm to the openness of the greenbelt. So there's not sort of an automatic gateway that if you're PDL, you are automatically appropriate development. To the contrary, it's only PDL which would not cause substantial harm to the openness of the greenbelt. So the other way in which to read this is to say, well, you give substantial weight to any harm to the greenbelt, but if you're not an appropriate PDL, you don't need to give it substantial weight. Now that is, I suspect, unbeknownst to the author, a game changer in the way in which we think about what appropriate development is. And to make that point good, I'm going to share my screen and bring up a legal judgment from 2016 from the Court of Appeal. And it's about what do we mean when we talk about appropriate or not inappropriate development. So here we go. Let me share my screen and just introduce this judgment. So from 2016, Lee Valley Regional Park and the Epping Forest District Council, a judgment from the Court of Appeal, and Lord Justice Lindblom. Now, Lord Justice Lindblom said in this judgment that there was a distinction between definitional harm and actual harm fails on its own logic. It means that the construction of agricultural buildings in the Greenbelt, though always appropriate, must nevertheless always be regarded as harmful both to the openness of the Greenbelt and to the purpose of including land within the Greenbelt, despite such harm being irrelevant to their appropriateness. What does that mean in layman's terms? Well, if we look at ignore footnote 55 for a moment and just look at what 154 does, which is saying development in the Greenbelt is inappropriate unless one of the following exceptions applies: buildings for agriculture. So if you've got a building for agriculture, the position used to be, prior to this NPPF, that was appropriate. Now, appropriate in the Greenbelt, i.e. you forget about the Greenbelt designation, so to speak. All other issues could be relevant in terms of, it could be flood risk, development in the countryside, isolated homes in the countryside. All those sort of policies might still apply, but the Greenbelt designation is overcome. It's appropriate development. And the point that the court was saying is, therefore, what you don't have to do, by virtue of it being appropriate development, that means the Greenbelt is regarded by the government as not inimical to the fundamental aim of the Greenbelt policy to prevent urban sprawl or protect the essential characteristics of the Greenbelt. That this is the real significance of development being appropriate in the Greenbelt and the reason why it does not have to be justified by very special circumstances. What the court are saying there, and the way the law has been up until this point, which is that the moment you are appropriate development, which there are various types of appropriate development, harm to the Greenbelt is essentially forgotten about. You're appropriate, so you don't need to think about harm to openness, or you don't need to think about the purpose of the Greenbelt, because by virtue of being appropriate, it means you've already been established as not causing that inherent harm to the Greenbelt. So that rather begs the question, what on earth is footnote 55 doing? Because that's saying to us, well, you don't need to give substantial weight to harm to the Greenbelt where you've got not an appropriate previously developed land. Well, we knew that. If you deleted 55, we knew that. If it was PDL that's not inappropriate, you don't give any harm to the Greenbelt. You've overcome the Greenbelt designation. That is what the court was saying. That is what appropriate development was. So why on earth do you have a footnote saying you don't need to give substantial weight? It previously, if you didn't say that, you'd say, well, yeah, you give no weight to harm to the Greenbelt because you're appropriate development. That's rather what appropriate development is. It's a development that doesn't harm the Greenbelt, hence it being appropriate. So this footnote, I think, potentially will cause more confusion than is necessary, because this would rather suggest you can both be appropriate development and potentially still cause harm to the greenbelt, which would undermine the entirety of the law on what appropriate development was. So I'm hoping, and this isn't me with sort of an agenda, whether it's right or wrong. I don't anticipate this was the intention, because it would have been consulted upon, one anticipates, if the intention was to upend all the law on what appropriate development has been for some years. So I rather anticipate that we might see a deletion of that or a clarification of this, because I don't think this reading of it is in any way consistent with what this footnote is trying to do. I think what this footnote is trying to say is, well, you should be more benevolent to PDL or grey belt land, because, whilst you might start with substantial weight, given the government want PDL and given they want grey belt land, you shouldn't be they are not so objectionable that you should give them substantial weight. I think that's what it's trying to get at. Whether it achieves that, I'm not convinced. Let's see if anyone jumps in. That was my first grenade. See if people got upset with that. No one seems vexed by that point. So some people are saying, I think it's bad drafting. You wonder if it was ever proofread by a barrister. I'm not sure. I didn't proofread it. That's all I can say. But I'd like to think that this sort of issue will be clarified, because I don't think it for a moment this was the intention of the author. But I think that it does introduce a level of uncertainty in national policy. The next point that we get to is grey belt. Now let's work through this, because again, I think there's potentially some mental gymnastics that are going on with grey belt land, which might be unnecessary. So grey belt is development of homes, commercial and other development in the green belt. So it's any type of development. Should not be regarded as inappropriate. So it's a new type of appropriate development where utilise grey belt land. Now, just pausing there, utilise grey belt land, and we'll jump down to page 73 where the definition of grey belt is contained. And you can see it's defined as comprising previously developed land and or any other land. So it doesn't have to be PDL. And we know that from the sequential test earlier that we saw in, when you're releasing greenbelt land, you start with your PDL, then grey belt that's not PDL, then we move on to other land. So grey belt embraces both PDL and non-PDL, but in either case where it doesn't contribute to purposes A, B, or D, which are those three purposes that we looked at earlier. And footnote 7 doesn't present a strong reason. So whether you've got heritage or flood risk or otherwise, any of those footnote 7 points don't weigh against it. So that's what a grey belt site is. If we jump back up to the exception for the purposes of development management policies, so development would utilise grey belt land, which is would think about purposes A, B, and D, and then would not fundamentally undermine the purposes taken together of the remaining green belt across the area of the plan. So you think about purposes A, B, and D here, and then seemingly you think about all the purposes here, because it doesn't claw out purpose C and E. Now, it's a different test, because it's talking about fundamentally undermine the purposes of the remaining green belt across the area of the plan. So purposes C and E, you're not thinking about in exactly the same vein as you would in the grey belt. But it's just as a mental gymnastic exercise. You're thinking about purposes A, B, and D. You think, okay, so it is grey belt land, but it does fundamentally undermine purpose C, so we fall against A. Struck me as somewhat an artificial and unnecessary sort of mental exercise that you think about some purposes here and the other purposes here. But anyway, that's seemingly the way in which the policy is drafted. Then there's a demonstrable need for the development proposed. But demonstrable unmet need, we're told, is simply means a lack of a 5-year housing land supply. So, clicks that would suggest a lack of a 5-year housing land supply is in itself a demonstrable unmet need. And then a sustainable location, which goes back to the earlier paragraphs on sustainable transport. But again, what counts to a sustainable location? I don't think is particularly, it's such a subjective element. So I don't think that these particular policies elucidate that. And then it also meets the golden rules requirements in paragraphs 156 and 157 below. Just before I move on to those golden rules, any questions? Across the plan is the bit worrying me. Yeah, Lauren, I can see that. I mean, notionally, people might say, well, that dilutes it, because you could say, well, that's a much larger area, and our particular parcel doesn't, there's still a great, a huge amount of green belt, which still fulfills those purposes. I can anticipate those sort of arguments being played out. Yeah, Tom is weighing in on that same point, Lauren, that it's vague, and I agree with that. James asked me views on the change to paragraph 154G, change to substantial harm considering PDL. Well, I think that it's encouraging PDL, that PDL, provided you're not causing that substantial harm. I think this is the government trying to get PDL through, which is, is consistent with the rhetoric of PDL being encouraged. I was always unsure that there was actually much of a policy backing for PDL, despite all the rhetoric in support of it. So this does actually give some teeth to that. Emily's asked, is it paragraph 155 A, B, and C together, or just one? Let me just go back to 155. The word and, so it's A, B, and D. So you've got to meet all of these, Emily. That's the use of the word and there means you've got to satisfy all of these points. It should be noted that the planning policy traveller sites excuses traveller sites from the golden rules. Yeah, I've noticed that, Lee. Thanks. Yeah, quite right. Okay. Is there a choice between 154G and 155 if you have PDL? Tom's asked the question. There is. There is indeed. If you are PDL, and if you were PDL and you're promoting the site, in your first instance, you would want to be just promoting it as 154G. These are all separate ways in which you can get a tick in the box. You could be both 154G and 155, but I would encourage you to mostly just go down to 154G, because there's notionally less boxes you need to tick in order to satisfy that. You don't have to satisfy all of the requirements of here, but you could do an either or. Turning to the 156, which is the golden rules. Now, here's an interesting thought, and again, I'd be interested to know if other people take a different view to this. This says, where major development, including the provision of housing, is proposed on land released from the Greenbelt through plan preparation and review, or on sites in the Greenbelt subject to a planning application, the following contributions should be made. What is interesting, and then it goes through the various requirements. B and C are relatively straightforward, necessary improvements to local and national infrastructure. Then they've got to be necessary. So, that ought to be straightforward. If they were necessary beforehand, that requirement notion doesn't even need to be there, because they were necessary. And then improvements to green spaces and whatnot. They aren't going to be the hurdle. It's A, which is the requirement for affordable housing, which meets the requirement here, which is you sort of 50%. It's not always going to be 50%, but by and large, it's going to be 50%. So that's going to be the big issue. The real point is, and I don't know whether this is intentional or not, but this doesn't just relate to Greybelt, as I see it. This relates to any major development in the Greenbelt, these golden rules. So you might be bringing forward a site and be proposing it for very special circumstances, and you say, we're not Greybelt, we're not appropriate development. We know we're just a great Greenbelt site, and we're just promoting it. But you're still major development, and you're subject to a planning application, which would suggest any major development in the Greenbelt henceforth will have to bring forward this level of affordable housing, unless you can do a viability assessment, for which we currently don't have any guidance, because that's going to be set out in the NPPG on viability, which we don't have, which would suggest Greenbelt sites on major development going forward are all subject to this 50% affordable housing requirement. Let's see how many people get upset with me about that. Yeah, quite right. Matt made the point that there's no golden rules for other types of development into commercial, industrial, and logistics. Quite right. And Elizabeth said you can't take account of viability. Well, we'll see on viability. Currently, there's nothing particularly, but the PPG on viability is going to be updated, we're told, in January. So we'll see what that says. Emma says it seems to promote affordable housing. Quite right. It does. I think the emphasis essentially is if you if you're going to have a greenbelt site, you've got to come up with some pretty good affordable housing, unless you can prove it's unviable. Is non-major development exempt from these golden rules? It is, James. It's only major development. Major is going to be defined as it is defined happily. There's a clear definition of major development in the glossary. This doesn't apply for national landscapes, which are more subjective, but for all other types of development, major development, there's a very clear definition for development where 10 or more houses will be provided. And then for non-residential development, but the golden rules don't apply for non-residential development, as Matt pointed out. So there is a very clear definition of major development for these purposes. And again, it doesn't appear that it's specific to grey belt. People don't seem as annoyed with me as I thought, which I'm delighted about. Yeah, and Tim said it was 15% above the current policy. That's quite right. I've taken that in quite quickly. It's 15 percentage points above the highest existing affordable housing requirement, which would otherwise apply to development, subject to a cap of 50%. So if you have a affordable housing requirement of 30%, then it's 45%. If you had an affordable housing requirement of 40%, then 15 percentage points above that would take you to 55, but you're subject to this cap of 50. So you're never going to go above 50 to meet this requirement. You might fall below it depending on what your affordable housing requirement is. And anything that complies with the golden rules should be given significant weight in favour of the grant of permission, which would mean if you conform with this policy, even as just a random speculative greenbelt site, as part of your very special circumstances, you should be getting significant weight in favour of the grant of permission. That doesn't mean you get the ticket, but it's a massive factor that weighs in favour of you. Let me see if anyone else has weighed in on that. Stephen says the PPG viability has already been updated. That's news to me. I didn't know that it'd been updated in respect to specifically greenbelt viability. Darren said, can you comment, Killian, if a site is released from the greenbelt, it isn't in the greenbelt, is it? Well, quite right. That's if it's been released from the greenbelt by a local plan, then greenbelt policies don't apply. There is potentially transitional arrangements that apply. We looked at that policy earlier. The number escapes me, but it does say that if you're releasing greenbelt sites, you should still apply the golden rules to them. So, but that would mean notionally in your allocation. Yeah, I'll put this up for you again. 151, where greenbelt land is released for development through plan preparation and review, the golden rules should apply, which would suggest the allocation should be saying, we release you from the greenbelt, but we want 50% affordable housing or whatever the relevant requirement is, subject to viability. Okay, that's this end of the section on greenbelt, except to say that there's a small section on renewables. That it's acknowledged that renewable energy projects will still comprise an appropriate development, or some elements will, but such various circumstances may include the wide environmental benefits associated with increased production of energy from renewable sources. So renewable sources are still in appropriate development, but there's sort of a tip of the hat towards those sort of schemes as contributing to very special circumstances. Let me just go back to the questions before I move off. Tom, you've asked your point about you have a former equestrian site with some existing buildings. Is paragraph 155A applicable in isolation, or do we need to take B and C too? I'm going to take that question. Yeah, I think that goes back to this point, which Emily asked about. If you want to be in conformity with this section on grey belt, then you've got to meet all the requirements of 155A through to D. I mean, if you're a equestrian site, you need to meet the golden rules, but the golden rules only apply to major development, so you sort of bypass D. But you'll have to meet these three. And is a demonstrable unmet need? Well, you have to demonstrate a demonstrable unmet need for equestrian sites, I suppose. I'm not sure how you'd go about doing that, but I'm sure someone would be able to come up with some inventive way. Climate change. I'm going to move on from the green belt, folks. Climate change. There's an acknowledgement the need to mitigate and adapt to climate change should be also considered in preparing and assessing planning applications, taking account the full range of potential climate change impacts. That is new, and that has been consistent with an understanding in the law, which hasn't actually been reflected in policy. Flood risk There have been some changes to flood risk policy, which are not as seismic as some people would have liked. So 173 tells us a sequential risk-based approach should always be taken in respect to individual applications and areas known to be at risk now or in the future from any form of flooding by following the steps set out below. We then turn to 175, which tells us sequential tests should be used in areas known to be at risk now or in the future from any form of flooding, except in situations where a site-specific flood risk assessment demonstrates that no built development within the site boundary, including access or escape routes, land raising, or other potentially vulnerable elements, will be located in an area that will be at risk of flooding from any source now and in the future, having regard to potential changes in flood risk. My understanding of that, or my clear understanding of that, is if you are proposing development, if you're saying, well, yes, we've got a site which is at risk of some form of flooding, but we're not going to be putting anything like any development or access or escape routes or any land raising in that area, then that means, well, you can avoid the sequential test, which is consistent with what the Environment Agency's guidance that was updated in August of this year. The Environment Agency came out with this guidance on national flood risk authorities, and they said within there that you may not need a sequential test if development can be laid out so that only elements such as public open space, biodiversity, immediate areas are located in areas at risk of source of current or future flooding. To my mind, this 175 is consistent with that. It's simply saying if you've got your site and you're going to put your landscaping in the area at risk of flooding, then you've avoided the sequential test. Just because you've got some flood risk across your wider site, that doesn't automatically engage a sequential test. It's what are you going to do in that area? And the definition of access, to my mind, I think ought to be interpreted as being consistent with the Development Management Procedure Order, which I'll just throw up on the screen again. Access. Now, this is access in the Development Management Procedure Order, which is in relation to reserve matters, which is talking about accessibility to and within the site for vehicles, cycles, and pedestrians in terms of positioning and treatment of access and circulation routes and how these fit into the surrounding area, which is critically, it's accessibility to and within the site. I'm not sure that it's justified to take a different interpretation of the word access for the purpose of the NPPF, which would suggest if you need internal routes within your site that go across areas at risk of flooding, that would engage the sequential test. I don't see this as license of saying, oh, well, we can avoid flood risk because of mitigation. I don't think that in any way would be inappropriate. And indeed, that would be inconsistent with the PPG, which tells us you don't consider mitigation as part of the sequential test. That's all relevant to the exception test. So I don't think this is a game changer. Some people might have thought so. It's essentially saying if you can just avoid those areas at risk of flooding when you're coming up with your plan, then you can avoid the sequential test. Got any comments on that? Tim's saying it's silly. You can't pick up and deal with on-site issues. Well, I don't write the policies. My job is just to interpret them. Kate's asked, do you need to avoid flood risk areas per the council's strategic flood risk area or per the site-specific flood risk area, which might be different? I would take it's the strategic flood risk assessment. So essentially, as I see it, Kate, you look at the council's strategic flood risk assessment. If that, for example, shows that you've got an area at risk of surface water flooding, you've got a large site and you've got a corner of it which is at risk of surface water flooding, developer comes forward with their site-specific flood risk assessment, says, well, yeah, we know that corner's there, but look, if we designed it in this way, we can build all our roads in such a way that whole corner we need not touch with development. We can just put our biodiversity net gain in that corner, so we don't need to put anything in there. That is what 175 is getting at, and saying that in those circumstances, you don't need a sequential test, as opposed to the developer saying, well, ignore what your strategic flood risk assessment says. We've got our own site-specific flood risk assessment. We've regraded all the classifications of flooding across the site. So ignore your strategic flood risk assessment. Just look at our site-specific flood risk assessment. I don't think that would be what 175 is driving at. Helen said, what about surface water flooding? It's all sources of flooding. All sources of flooding. Any form of flooding. Again, this isn't my policy, but that's what the policy is. So if you've got any risk of flooding, whether that's surface, canals, sewers, groundwater, fluvial, coastal, whatever it is, from any source, it engages. Tim said, how would 175 be applied in an area of defended flood area? I'm not quite sure the question, Tim. If you want another crack at it, I can have a go at it, but I'm not sure what you mean. I mean, I don't know that defended flood area is relevant to the question of flood risk. Ultimately, do you have a risk of flood risk across the side that's greater than low? Louise said, what if you had a new building proposed in flood zone 1 and existing access in flood zone 2 and 3? I think in those circumstances, potentially you could avoid it. Potentially, I think that's more arguable because notionally you'd say, well, our development proposal, we're not proposing any development in flood zone 2 and 3. The development's already there. So I think that could go either way. Dave says, I hope you've gained an insight into what it feels like to be cross-examined. The difference is, Dave, I can pick and choose which questions I want to answer. Okay, moving on. I think we've dealt with most of the big ticket points now, folks, but I'm just going to finish off. I won't be long now on the final few bits. Conserving and enhancing the natural environment. There's a very short addition about supporting swifts, bats, and hedgehogs. Again, I'm not sure that's going to make much difference. Otherwise, no changes there. Heritage, no changes there. Minerals, no changes there. And then implementation, the purpose of decision making. What we have, any reference to a 4-year housing land supply, which existed in the old NPPF, that's gone. So it's all 5-year supply now. That's the relevant test. What it's saying here in this section that I've highlighted is effectively that where a local planning authority have a local plan that's adopted for the first 5 years, whatever it is the requirement in their local plan, that's the relevant requirement. Now, it might be in the background, the standard method is going up and down and it's going higher and higher and higher. This is saying, well, even if your standard method figure is great in the housing requirements set out in adopted strategic policies, for the first 5 years, that doesn't make those policies out of date. So you could have a requirement in your local plan, which for argument's sake is 50 dwellings per annum. And it might be that after 2 years, that standard method has shot up to 200 dwellings per annum. So it's 4 times. I mean, this is somewhat dramatic, but it's 4 times the requirement set out in your local plan. It would be, this is saying, well, that doesn't in any way undermine what's in the local plan. The local plan is an up-to-date housing requirement figure for 5 years. And then at 233, we see a deletion of annual position statements. They were an interesting idea, but there wasn't much uptake with them. So the government decided to abandon annual position statements. And then we move on to implementation for the purpose of plan making, which I'm not going to labour because it's so site specific and it's, authority specific. And it's actually not that tricky to work through. You've just got to think through your relevant dates. So 12th of March, 2025. From that point, that's when policy in the version will apply, unless you sort of fall into one of the various different subcategories. And again, I'm not going to work through them because there's just so many different iterations of them. And it doesn't strike me that they're that complicated. Famous last words. There's also an interesting reference that the 2012 version of the NPPF is still extant policy for those plans were submitted on or before the 24th of January 2019. I'd love to know if there is any such plan that's still knocking around, that's not gone through, that policy is going to apply to. Presumably there is, hence why it exists. You can see if a number of people are joining in with questions. Yeah, it says Dorset is the only council with planning inspectorate annual position statement. Well, that rather speaks to the point, Darren. I anticipated when it was first announced there wasn't going to be much uptake on these annual position statements because it's both additional work, and if you're so confident you have 5-year supply, you're probably thinking we don't need this. Finally, in the glossary, we see a few definitions that have come in. Social rent has come in as a definition of affordable housing. There's a few other tweaks in terms of definitions, but one that jumped out to me, so local housing need, it's the number of homes identified as being needed for the application standard methods set out in National Planning Practice Guidance. They've deleted the text that was in the previous version that said, unless an alternative scenario can be justified in accordance with paragraph 61, which again, making it clear it's more mandatory, the standard method. those national landscapes instead of A or MB, which is all throughout this new NPPF. And then there was one point which previously developed land which has been lawfully developed. And it talks about any fixed surface infrastructure associated with it. I mean, what it's really talking about is hard standing. So PDL can extend to hard standing, which has been a question mark. Most of the time, PDL has been thought to include hard standing, but this makes it beyond clear. To my mind, this text is going to give rise to a legal challenge at some point, where it says has been lawfully developed. Does that mean it's lawful now? Or does that mean at the time it was being developed as lawful? And what I'm really getting at there is circumstances where you've done some PDL and through the passage of time it's become immune from enforcement. In those circumstances, has that been lawfully developed? So are we only looking at PDL that's been done by virtue of a planning permission, i.e. at the time it was done, it was lawfully developed, so it was lawful to do it at the time? Or are we thinking about anything that's immune from enforcement? So it's development that is now lawful to the passage of time. Now, it might make me being a lawyer, but I actually do anticipate, I can think of a number of scenarios where that could actually play out, where you're trying to argue your PDL and someone says, well, why are you PDL? By virtue of a planning permission or by the virtue of the passage of time? Okay, Robert thinks lawful now. Lawful now, I think. I don't necessarily think that's wrong, Robert. I just think that the language is sufficiently vague. It could give rise to both interpretations. And sure, the NPPF cannot erode the statutory effect of Section 171B that defines when something is lawful for planning purposes. Well, it defines circumstances when it's immune from enforcement. But it's simply, and again, this might just be me getting excited about language, but lawfully developed. Is that it was lawful at the time it's developed, or that it's lawful now? Because if you just said land which is lawful, land that is PDL that is lawful, and has that might be a different way of phrasing it, but it might just be a matter of semantics. Okay, folks. Well, that covers hopefully a whistle-stop tour of everything in the new NPPF. Thank you for those who contributed with questions. And thank you so much for joining me. My name's been Killian Garvey. It will continue to be. And hopefully you all have a wonderful Christmas and New Year. And I'll catch up with you next year. Thank you so much. And don't forget, this will be posted on YouTube next year. And we'll put a post around when that's done. So, well, thank you so much, folks. And I'm going to end the recording now. Thank you.